well, thank you. I hope this seminar becomes informational and gives you something to walk away with. You guys can build connections. Feel free to look these speakers up. All these speakers are kind of intertwined in some way with their topics, so that either you learn something new, or you might get the general gist, or you can validate what you already know. But I hope this is becomes very, very empowering. So next we'll have, the next speaker is going to be Narek Zohrabyan. He is the founder and principal IP attorney at Phil IP Law Group, correct?
Yeah.
Cool. His firm does a lot of services for patenting, trademarking, any procurement and litigation, does counseling. He actually used to work with the Patent and Trade Office, if I'm not mistaken, U.S. Patent and Trade Office. And he used to even be an engineer, if I'm not mistaken, working with Boeing, and he did like work with the Navy. So with that, I'd like to introduce you our next speaker, Narek Zohrabyan.
Yep. All right, good morning. Glad to be here. Thank you for introductions, Ace. So I am an IP attorney. Fun stuff, right? Trust me, I'm not going to bore you to death. So IP stands for intellectual property. What is intellectual property, you might be asking? Well, you can think about more traditional forms of property, let's say real estate, personal property, goods of different types. Well, intellectual property is the intangible form of it. So there isn't anything that you can physically touch. It's something almost lives in your mind, right? So it's intangible property, however, it's still very valuable. You can take that, you can trade it, you can license it, you can buy and sell it, and definitely monetize on it. And as you'll see later on in my talk, it's a very big part of the U.S. economic engine. It produces jobs, it produces income, and it's pretty much the #1 export from the U.S. So we'll go over different types of intellectual property, what they entail, how to protect them, and then I'll take your questions. All right, let's see. Here we go. Okay, so this is a really cool graphic I found. It's put out by the World Intellectual Property Organization. It sort of outlines the different type of intellectual property that's out there. I'll be talking about each one of them. So trademarks is one of them. I'm sure you've seen a lot of symbols like TM, SM, and circle R mark, and I'll talk about what all of those mean. And then we also have patents, which deal with inventions, right? Things that do solve certain problems or methods. And then there's also design patents. I'll go over that as well. And then we'll talk about copyright, what that entails. Generally speaking, that's expressive content protected for the author. And then there's the fourth kind of intellectual property, which for now I won't mention. It's actually not part of this graphic. It's going to remain secret, and you'll see why. So we're going to talk about trademark and service marks. What are they? Right? The traditional forms that you and I are very much familiar with are words, logos, taglines, slogans, right? So the traditional kind of thing that you and I deal with as consumers, go to the mall, go on Amazon, you're looking for something particular, I don't know, Adidas shoes or Apple computers, right? So you see something like this, right? It's a source identifier. So Nike is very famous with their brand. So they have their Nike names registered, they'll have their swoosh mark registered, as well as their tagline, just do it, right? So you also have Apple, and Apple has gone through iterations in adopting their mark. So traditionally they started out with the rainbow-colored apple, and then they switched over to their more sophisticated modern look. And it's everywhere, right? So it's very, very big. Essentially, what are these? These are source identifiers. They tell the consumer that this product or the service that they're providing comes from this particular company. There's many reasons why you would want to do this. One is, of course, branding. You want to have a following. You want to have a sort of loyal customer base. Another point why you want to protect your mark is to provide a consumer a way of identifying that your product has some value, right? So if something, let's say, happens down the road, I don't know, you have a computer, blows up, well, you know who to go to, right? So I'm not going to go sue Nike because my Apple computer broke down. I'm going to go to Apple. The other aspect is, of course, monopoly monopolizing and monetizing it, right? So you don't want people to knock off your brand. You don't want them to produce a cheaper version of it, and then also devalue your brand, devalue your ultimate product, because that is generating revenue for you. So these are the traditional forms that everybody sees, but there are also non-traditional ways of trademarking and service marking, whatever you're providing. By the way, TM, I should mention, TM is particularly used for goods. So if you're selling a product, a thing, right? So you would traditionally identify that as a trademark. But if you're offering goods, for example, myself, I'm offering legal services, well, I would operate under the banner of SM, which is a service mark. And then I'll get to when you register your mark, then you can use the circle R symbol to designate that this is a registered mark. And we'll go over that in a little bit. But the other non-traditional way of protecting your mark are sounds. Well, you would be surprised to hear that sounds are actually protectable, and I hope we have some audio, some speakers here. Let's see if we can get this going. I guess not. Anyway, so this is Homer Simpson. Some of you are familiar with this, right? So 20th Century Fox registered Homer's catchphrase of dough, right? So this is a very symbolic thing for this particular show, and it's been running for about 29 seasons now. And they run the stats on it, so Homer Simpson has said this about 1,100 times. So it's a very unique symbolic thing, and gets the consumer to identify this particular show with Homer's catchphrases and among other things. There's many other sound marks that you might be familiar with. For example, MGM has their iconic lion that pops up in the beginning of the movies. Does the lion roar? So that's also very much protectable and registered. So it's, again, another way of associating something, so in this case a sound, with the product or the service that is being protected. And we can move on to colors. You'd be surprised. Even colors can be protected as a trademark or even a service mark. And I have one example here. Let's see if it comes up. So we have this blue or teal looking color. Anybody know? Okay. Somebody already said it. Tiffany. Okay, there we go. Yeah, Tiffany. So, right, it's an iconic brand. So they have it everywhere. They have it, I think that's the button for a glove. They have their iconic boxing. You can't, confuse that with, I don't know, cheapy version of it in Costco. Well, sorry, I said Costco, so they just have the beef with Costco. Costco was there selling sort of diamond rings they were calling Tiffany's, in which case it wasn't really Tiffany's. But Tiffany's was able to shut them down because of that. And anyway, this color is very unique. I guess now they're expanding into sort of home goods type of products and glass. No, I'm kidding. They're not selling glass. But I thought it was interesting. Okay, so that's colors. You can protect it. The traditional, the iconic red color for the shoes the ladies wear, the Louboutin. Yeah, that's also trademark. So because it's a source identifier. Also smells and scents. Believe it or not, you can trademark scents. I have one example of it here. Some of you might be familiar with it from your childhood days. This is a container of Play-Doh. So Play-Doh came up with this iconic smell back in the day, and in their 50th anniversary, they actually launched not only the product that was redesigned, but they also have a cologne. I'm not kidding, you can go on Amazon and buy a cologne. I don't know why anybody would want to wear this, but hey, it's available, okay? Interestingly enough, perfumes are not trademarkable. Why? Because they have inherent quality, which is the actual feature of the product itself. It does not function as a source identifier. Perfume, the whole purpose is for you to put it on and smell good to other people, I suppose, right? So you cannot have a trademark that is inherently tied in with the characteristic and nature of the underlying goods and products. So we covered sounds, colors, smells. Well, what about taste? You'd be wondering, taste. So there isn't anything out there that I can find that would cover taste, because probably for the same reason that you cannot trademark perfumes. However, I think you probably could. I mean, I can think of, let's say, medication that, I don't know, peppermint cough drops, for example, right? I mean, the inherent nature of a cough drop is to provide some soothing, right? So it's like a medication. However, if you add some sort of trendy taste to it, or bubble gum, or I don't know, peppermint, maybe, well, the consumer might identify a particular brand of cough drops and go and buy your product rather than your competitor's product. Actually, Pepto-Bismol that I'm thinking about, and that might be a trifecta. They got color, they got smell, and scent, taste as well, probably, right? I mean, they got that pink look, they have that smell, right? I'm sure you guys are Pepto-Bismol. And then the very iconic, I guess, memorable taste that you would get ingesting it. So those are some of the traditional forms of trademark that you can get the protection on. And there's some sub-forms of protecting trademarks, and they're called trade dress. It's a subgroup of branding. For example, we can do it in the form of product appearance. I'm sure you're familiar with this. So we're talking about packaging of the product that it appears in. Sorry, the appearance of the product itself. So the iconic Coca-Cola bottle, I mean, this is so unique. It's been a world over, people identify this with the company that provides soft drinks. So I'm sure if somebody goes out there and starts selling, I don't know, Mountain Dew or something else, iced tea, using this bottle, Coca-Cola is going to be after them. So this is the product design that could be protected. So now we can talk about product packaging. Okay? So I have an example of this. Let's see if it comes up. Okay, what about this? This is an interesting product packaging. Technically, it's not a product, but they're providing a service. They're just providing entertainment, adult entertainment service for women. So I'm talking about the Chippendale look, right? So they got the bow tie, they got the cuffs. So this is actually product packaging. The men are not the product, so don't. It's a service mark. They're providing a service, right? So there's another way of protecting it, right? So you probably can't have somebody else using this to knock off and beat them to the market. Another form of product packaging would be the iconic, I guess, the Apple phone, right? They come in like a white box, or even the Tiffany that we talked about, right? So I'm sure you can't go out there and just buy the box or produce the box. You can change the label, put whatever, Alpha Omega as your company name, and then start selling it. I'm sure Tiffany's going to be after you because you're just adopting it.
We actually use the Tiffany name on a product we sell as a color and that letter.
Oh, yeah.
That, so we change it to Robinette, which is the
Okay.
color of Tiffany's.
Yeah. Oh, I'm sure they're going to be after you. And then that's a good point. And I'll talk about monitoring and policing your rights because that's incredibly important. Okay, so those are the traditional forms and the non-traditional forms. So the takeaways from trademarking perspective. So, and this goes hand in hand with working with your marketing people and strategizing, trying to figure out what brand to use, right? So the first thing you want to think about doing is conducting a clearance search, and you can have a clearance search conducted by IP professional or branding agency. So what this entails is essentially looking at public databases and private databases to find companies out there that are using that particular name, right, that particular brand. And the reason you want to do this is because obviously you don't want having conflicts. In the case of Tiffany's, you obviously don't want to brand your company Tiffany's, or maybe have a variation spelling of Tiffany's, you know, maybe IES or maybe one of the S or something like that. Because last thing you want to do is adopt a mark, spend all this money getting your company started, website, social media, getting this whole following going, and then 2-3 years down the line, you get slapped with a cease and desist letter saying, hey, you know what, you need to shut down or you need to rebrand. And on top of that, you need to pay for corrective advertising, right? So like this is the worst case scenario. You do not want to do this. So from the due diligence perspective, you want to spend a little money and do a little investigation to find out if your mark that you want to adopt is cleared or not. And with respect to picking a mark, okay, what sorts of things you want to look out for? So from the trademark perspective, if you're much more protected if you pick something that is inherently distinct. It does not describe your goods or services. Doesn't describe a characteristic of it. Because why? I mean, if you're describing, if I have Narek's plumbing services, well, I shouldn't be able to monopolize on plumbing services, right? Because Joshua also has plumbing services and Sarah has plumbing services. So it's describing the service I'm providing. So it should be something completely arbitrary and fanciful. For example, if you think about Apple computers, right? So Apple has their, it's just the Apple logo, right? So what does Apple have to do with computers and phones and technology? Absolutely nothing, right? But that gives it the value because it's inherently distinct. It's not really descriptive. It's not generic. Even with generic marks, you get absolutely no protection. So from that perspective, you want to keep that in mind when you're talking to your marketing expert, your branding strategist, or whatever. You want to keep those things in mind. And with regard to trademarks and service marks, the key thing that I want you to remember is there aren't any formalities to follow. Trademark rights come from actually using them. If you do not use them, you're not going to have protections that are afforded to you. So some people think that you just go out there and register it and voila, you have protection. That's not necessarily the case. In some countries that may be the case. In the United States, the rights are afforded to you once you start using it. And you have to use it properly. And you have to use it in the trademark sense, in the sense that it identifies the source of the product and services. So, for example, you don't want to use it as a noun, you want to use it as an adjective. I'll give you some case points. So, for example, Xerox, right? Everybody knows Xerox. So Xerox says, this is a very, very famous brand, and they make copy machines and all sorts of other technology. But Xerox over time has lost the source identifying component of their trademark. Why? Because people use it as a noun or a verb. Like, go Xerox this document for me, right? So you have to be very cognizant about monitoring and policing it and making sure other people will use it properly, use it as an adjective. Instead of using it in the sense that you want to Xerox something, you say, hey, you know what? You should be using it such that you're telling people to photocopy your document using a Xerox branded photocopy machine. Or in the case of Kleenex, napkins, the brand is Kleenex, right? So Kleenex and Xerox over time have become generic and they've lost meaning and they've lost their value. The other takeaway is monitoring and policing, like I said, is part of that. So you have to enforce your rights. If people are using it or misusing it or copying it, you have to be active, send them a cease and desist letter, take it in court if you need to. So this is very much part of keeping a healthy trademark as part of your IP asset. And then along the way, and it can be in the beginning or somewhere once you've done some exposure and following, is registering the mark. Provides you with nationwide protection in the case of trademarks registered in the United States. Also, you can file it internationally. Let's say if your market is in the European Union or Asia or what have you, you can certainly do it through international treaties such as the Madrid Protocol. So it all depends on what your market is. And then one other thing I wanted to mention about this, because I deal with a lot of clients who manufacture things overseas and they bring it in the US and other markets, especially with China, I should say. You have to tread very carefully with China because what ends up happening is there's a lot of bad actors in China. So you would go, let's say, have a company that are manufacturing your widget, and you have whatever brand on it, Alpha, let's say, on your widget, and then you bring it here. What Chinese manufacturers do is maybe they'll contact a cousin from another province or somebody they know in the neighboring manufacturing plant, and they'll go and register the trademark in China. Well, guess what happens? Once they register the mark in China, even though they're not using it, right? So it's just, just fabrication. They just filed it. They filed it for the whole purpose of renegotiating your terms. Right? So you're buying that widget for $5 a box, right? So now they're going to renegotiate and maybe buy it for them for $7. So even though you're not selling the product in China, even though you have no business in China except that it's being produced, it's a very good idea to at least register your mark in China. So something to keep in mind for people who have consumer products they want to bring into the market. All right, we can move on to patents. So this is my reaction. Okay, I gotta wrap this up. So patents. So I used to be a patent examiner. I'm just going to give you kind of a rundown of what patents are. So they're inventions, and they come in different forms. So utility inventions, utility applications are essentially reserved for inventions, something that solves a problem. It's a system or method of doing something. And there's various ways of going about it and protecting utility inventions, I should say. So the first thing I think we want to do from the ideation stage is to file a provisional application, which is essentially getting the process started. Once you get your manufacturing, your distribution, your investors, your marketing, everybody in line, and then you can think about actually filing a regular application and going through the review process and then getting this approved. Utility applications or inventions, I should say, that are granted, you get a 20-year limited monopoly. So in exchange for making this information public. So you have 20 years of excluding anybody else in the United States, in the case of US patents, from importing, selling, offering to sell, and using it in the United States. So it's a very powerful tool. Design patents deal with the ornamental nature of the product, let's say. It's the aesthetic features, it's the look of it. It's not what it does, but what it looks like the Coca-Cola bottle I was showing you earlier, so that's to be one example. So design patents are relatively easier to obtain and relatively cheaper. However, the term of protection they get is 15 years. But certainly 15 years is a lot of time for you to monetize. And plant, I don't deal with plants. Plants are a very distinct area in patent law. So it deals with protecting new breeds that are asexually reproducible. Okay. So just an example of the first patent that I approved when I was in the patent office. This is a really cool invention. It deals with determining the blood alcohol content of a person who's under the influences of drug using imagery. So somebody takes out, let's say, a smartphone, has a camera on it, you take a sampling of their eye movement, and based on that eye movement, it correlates and says, okay, your blood alcohol content is 0.06 or 0.08 or whatever. It's really cool stuff. I don't know if they're using it in law enforcement, but I thought it was phenomenal, so I allowed the case and they got a patent on it. On the private side, once I was working, this is one of the inventions that I prosecuted. In our parlance, prosecution means essentially the process of obtaining a patent. So this is a design patent. One of the clients came in and this patent was, similar patent was out there, and so they came to me with a specific problem that they needed to resolve. They said, hey, look, here's the patent. We want you to propose design around. So we want to modify this and then have our own patent on it. So that's something I did for them, and then we got that. Okay, so I gotta hurry this up. Third type of intellectual property is copyright. So we're talking about expressive content, music, pictures, literature, that kind of thing. So it's easy to come up with. One thing I want you to take away from this is you don't need to follow any formalities. Once the work is created, it's expressive enough, there's a modicum of information that's contained in some sort of tangible medium, so it's not just drawings on sand. It's something on some medium that can last. So you automatically get protection. Now, if you want to enforce those rights, you have to register it and go to federal court. And if you want to register it as soon as possible, because there's a lot of statutory provisions that provide you protection, such as fees, damages that cannot be calculated, otherwise you automatically get them, attorney's costs, that kind of thing. The last type of intellectual property, which I told you secret, is trade secrets. Right? These are also very powerful. There's not a week that goes by that I don't hear one company stealing another company's secrets. Secrets are what? Like it could be anything, almost anything. Your client list, your price sheet, your marketing analysis, statistical, demographic figures that you combine and gotten from your marketing, let's say, department. Your supplier list, all of those things. So long as they're sufficiently kept confidential, they're labeled as such, as proprietary, and it gives you an economic advantage, you want to protect it. The way to protect it is to have employee handbooks in place. You have people signing agreements that they understand that this is confidential. They cannot take this stuff home, can't take the computer, their hard drive home. In the case of Waymo versus Uber, Waymo took the hard drive essentially to Uber, and they got slapped with a $200 million lawsuit that they won recently. So that's another way of protecting it. Why is this stuff important? Well, as I said before, intellectual property is incredibly useful part in your business. It accounts for about, the latest numbers that I got is about 6 trillion of US GDP, employs quite a number of people. So you want to certainly look into this when you're launching your business, protecting it, whether that's the mark that you're identifying with, whether you have underlying inventions, if you have confidential proprietary information, or copyrighted. Even, I forgot to mention, the software code is certainly copyrightable. So it's not just traditional forms of expressive content. Software is also copyrighted. And I'll take any questions if we have time. Somebody back there. And somebody up here.
So can you provide us a little range for the due diligence cost, like thorough due diligence,
For
including attorney and research of the patent inventory
for patents.
or trademarks?
Okay, so it's going to be very different. So trademarks, usually doing minimal due diligence, you're probably looking at like $400 or $500. On the upper range, and it depends on how broad you want to do it. Right? So you want to do US only, you want to open up internationally, so you're looking at something along the lines of maybe 1,100 upwards to 1,800, let's say. Something along those lines, those are reasonable figures. So you want to be very careful at picking your market, right? You don't want to be spending a bunch of money on international searching when your market is only going to be in the US, let's say, or even regionally. Yeah.
Okay, so because so you said top 2,000, is that correct?
Probably, yeah.
Yeah. Okay.
Yeah.
And so am I correct that if you're manufacturing a product, you have to patent in the manufacturing country as well, although you're going to sell it in different
Yeah, that's a
countries?
good idea too. I'm glad you brought it up, especially with China. There's just so much shenanigans happening in China, some of my clients. So certainly you want to file some sort of a patent over there, because if you have a competitor making something similar, you can, even though you're not, let's say, selling the product in China, you can stop them at the border. Right? So you can stop them exporting it out of China. Okay? Even though you have no customer base, you don't care, it's not going to sell over there. It might be a very good idea to get protection there. Yes? Oh, we have more questions over here. Oh, there you go.
So as far as when you work for a company and the trade secrets, is there like a test you could use to determine what you can take from what you learned at that company and use it on your own? Like, what's the legality of that? So it seems like there's a threshold, like you could use a program that company used, that seems legal, but is there some sort of test or that you use as a lawyer that determines whether it's allowed or not?
Okay. So certainly the know-how that you take away, like things that you learn how to do, certainly the company cannot forbid you from, let's say, taking skills that you took from the company while working. But if they have proprietary software that they're using, certainly if they've done, whatever they need to do, protect it with confidential labeling on, splash screen or something like that, or you have unique access and they're monitoring that IT department limits who has access to what, they log in all this information, and you sign some sort of an agreement with them, then those things probably not, right? But the know-how, the skills that you pick up while working previous employers.
Or even how something's organized, like the chain of command, or are those things?
Yeah, those are kind of tough questions. I guess it's going to depend on how unique that particular structure is that provides them an economic advantage. I mean, does it, or I don't really know the circumstances of the
Just in general.
Yeah, these things are kind of very hard to predict, and it is very much fact specific. So it's going to depend on what sort of economic value that company is reaping from making that particular structure or proprietary setup that they have going on.
All right, thank you.
Thank you.
Thank you, Narek.